So there are the distinction on. There is also a distinction on business to business portals, and there is also business to consumer portals. So we are currently focusing, on the business to consumer portals, because we are seeing, how the counterfeit goods are affecting the consumers in my today's presentation. What is it that has actually, helped or, in a way encouraged people to sell goods online? Obviously, the anonymity of the internet, is one area that you can actually hide your identity. You can, create the names of the company and upload your, goods without having to do any sort of KYC. So, until about 3 to 4 years back, it was actually quite possible for anyone to create a pseudonym, go and create a profile on the likes of Amazon and Flipkart and sell their goods. And it is only now that, with the GST #1 coming in, they ask for your GST registration, they ask for your PAN number of the seller and also of the bank account, and obviously carry out some sort of a due diligence whereby they match the name of the company with the bank account details as well as the PAN number and the GST before they enroll a seller. But still, there are a lot of spaces, such as the creating a Facebook page and then enabling the transaction to happen through Facebook page, having WhatsApp numbers being placed there, or linking it to a wallet such as Paytm or Google Pay, or Google and Amazon and others. And you can actually transact without having to disclose where you are based and where are you, and if you have any proper business at all or not. And also, when we talk about the due diligence being carried out, not all portals are alike. When we talk about the big portals like Amazon and Flipkarts or even Snapdeals of this world, they do have policies and procedures in place where they do carry out the due diligence. But there are many other smaller portals where, in order to enroll more and more sellers and in order to attract more and more consumers to come to them, they actually do not insist on many such documents, which would help them to track them down later if they were found to be selling fake goods. Obviously, in the online world, most people take the images of the genuine goods and upload them, and when the goods actually arrive, they may be counterfeit, and people buy it looking at the images of the product. Not many of the portals actually carry out due diligence to see whether the photographs actually match with the product which is supplied. It is sometimes practical and practically also not possible, with all the logistic challenges to do actually that sort of a verification. The luxury goods in particular are much more targeted in terms of the counterfeit goods because of the high margin. And that's not just in India. If we go anywhere in the world, the luxury goods are the most affected by e-commerce, the online sale of goods. There is also completely another area which I will not be talking about, and which is another challenge which the brands are facing. Many of you would have seen that brands do organize, their second sale, or sometimes they have, a certain amount of goods which are left with them, which they sell on a huge discount. Many of such goods are bought by traders as a lot, and then thereafter they refurbish them and actually put on sale as genuine goods. And in many cases, the luxury goods, which have been discarded or by the manufacturer, do come online to be sold as first-hand genuine goods. From the legal point of view, also there is, under the Information Technology Act, there is a definition of what is called as an intermediary. An intermediary means any person who has been only instrumental in facilitating a certain transaction. So you can imagine, the something like if you have an Airtel, Jio, or Vodafone connection, then in that case, the telecom service provider who is providing you that 4G connection is actually an intermediary. And the law says that if suppose you use your mobile phone to carry out any illegal activities, for example, if someone was using that phone to carry out a serious crime of, for example, a kidnapping, or issuing a threat to someone, which could be an offense under the Indian Penal Code, the service provider in this case, whether it is Vodafone, Jio, or Airtel, will not be held responsible for the activities of the person, because they are merely acting as an intermediary to provide them that mobile phone connection. Similarly, an e-commerce portal has been held to be an intermediary, and he is not responsible as per Section 79 of the Act. They are given what is called as the safe harbor to if there is a counterfeit goods being sold online by a seller, because they are held to be mere intermediary who provided that space, and provided they have carried out due diligence. So as I was mentioning, so this slide mentions about the Section 79 of the Act, but they must play no role in such transaction, and they must observe due diligence and follow the other guidelines, which is intermediary guidelines, which have been issued under this particular section by the under the Act. And so the immunity is remains till such time intermediary has neither conspired, abetted, or induced in the commission of the unlawful act. So they are not at all playing any role other than just performing the function of an intermediary. And the intermediary guidelines also provide that in case the brand owner complains to the intermediary about certain illegal activities, in this case being the counterfeit goods being sold, then he must take action within the 36 hours of such notice. However, there is again complexity which has arisen in this case from a judgment of the Supreme Court, which actually came in the context of a copyright. What really happens is that if suppose I am a celebrity, or I am someone who is known, whether in the business circle like a businessman, or I am a film actor or someone politician, people do write against me. People may put certain articles or blogs or things about my activities, and they could be termed as defamatory, and I can write to the such news providing websites to remove that content. Now, when a case of the nature actually relating to a particular section under the Information Technology Act, Section 66, where a particular clause of it which provided that the government can, under the threat of security, ask for any particular person to be arrested, and that particular piece of blog to be taken down, which went up to Supreme Court in a case called Shreya Singhal case. In that case, the Supreme Court on Section 79 ruled that the intermediaries may not have the technical knowledge to know whether certain goods are counterfeit or not, and they can insist on a court order being provided. Now that thing actually adds complexity to the whole phenomenon, because the brand owners in many cases are not willing to go to the court for every matter, every counterfeits listing that they see, for a simple reason that they may have a budgetary constraints, as well as they may not want to, they probably do not know the identity of the seller, and they also do not know whether the particular seller has what kind of quantity of goods he is holding. So they generally rely on the intermediary to inform them to take them down. Now, many of the intermediaries, when they see an obvious copying, they do bring it down. But in some cases, we have also observed that they do take shelter under the Shreya single judgment and say that please get me an order of the court, because I cannot make any determination of whether certain product that is listed and is being complained by you of being counterfeit is beyond me. Particularly, we have seen smaller websites, lesser known websites taking advantage of that judgment. Most of the times, the well-known ones, whether the likes of Amazon and Flipkart, generally do try to cooperate with the brand owners, but they do as well in certain cases where the complaint is more of a lookalike brand rather than an identical brand, do sometimes turn around and say, please get me a court order, otherwise I will not remove this listing from my portal. I also wanted to share with you this particular judgment of the Delhi High Court, which emphatically laid down the intermediaries are protected as under Section 79. This particular case was brought by T-Series against a portal, MySpace. This used to be quite popular about 10 years, roughly about 8-9 years back. It still has a big following in US, close to 1 million subscribers, but it is not so popular here. And it's, you could say, a mishmash of Facebook and what is currently Spotify or iTunes, where you can actually share music, upload music, etc., as well as your photographs. So it's kind of that kind of in a website. It was quite popular at one point of time. So the T-Series complained against MySpace that there were pirated music or which violated their copyright was being shared by and uploaded and shared by many of their subscribers, and the MySpace was generating revenue from there because of the popularity of the website. The another side of the these kind of portals is also this, that many a times you wonder where do these portals make money. So the more the number of subscribers they have, the more they attract the advertisers to come and advertise on their portals. And that's why when you play a YouTube music, every 3 to 4 minutes it is disrupted by an advert being played, because you have not subscribed to it and you are thinking, I am actually listening to free music. Why should I, pay for it? But then, you actually in that case, the money is being made by the portal through the advertising, and you are the product in that case for them. As on a lighter side, people say there is never a free lunch or a free, dinner. Wherever there is in the online world, if anything is free, then you are the product. And they are actually targeting you to make money. So in this case, coming back to the MySpace, the single judge of the Delhi High Court held that the MySpace acts constituted an infringement as per Section 59(1) of the Copyright Act, and he said that because they were clearly should have had the knowledge of such music being uploaded. Therefore, they were playing more than intermediary role. Appeal was filed against this, and to the two judges bench, or what is called as the division bench of the Delhi High Court, and the court held that there was no actual knowledge on the part of the MySpace that could be proved. There was an algorithm that they had set out, and the music was being automatically uploaded. and there was nothing to show that the MySpace played any active role in encouraging that infringement. They were merely providing the space and therefore acting as an intermediary. So today, most of the cases on any counterfeit goods or any infringing products being sold on these portals, when it is brought, most of the time they take shelter under Section 79 to argue that safe harbor provisions apply, and we cannot be held for any sort of infringement. We can at best be directed to remove such listing, and and that's how our sort of obligation or our duty ends. Now, as the jurisprudence has developed in the area of intermediary, there are obviously courts taking differing stands. In some cases, they have also propounded certain more harder stand as well, as we would see from this decision, which again comes from Delhi High Court. In this case, there were counterfeit goods being sold on shop clues, and the case was brought by Skull Candy, which sells the music, headphones and Bluetooth, devices, etc. And the shop clues argued that obviously, in line with the other cases, that we are an intermediary, therefore we should be provided safe harbor, and we are willing to remove all the listing of whatever has been complained of. But the judge in this case actually looked at the entire transaction and the role played by the e-commerce portals, and particularly in this case, it culled out 26 tasks which were being provided by an e-commerce portal. For example, there were tasks like they collect the money on behalf of the seller, they store the goods on behalf of the seller, they actually advertise those goods in the form of sponsored listings. There are also return of the goods is being done by them. So when the judge said that, look, if you look at all of these tasks, it seems to me that these intermediaries are performing tasks of more than just being an intermediary. They are actually playing an active role in a particular transaction that happens on the e-commerce portals, and therefore I hold them liable. An appeal was filed against that order to the two judges bench, the division bench, which stayed the order, and it is still pending, arguments, and we will see how things pan out. But 2 weeks back, again, there was another order which was widely reported in the newspapers of a Karnataka High Court ruling. Again, saying that Flipkart is an intermediary. In that case, there was a listing of certain pharmaceutical products which were to be sold, which could be sold only on prescription, but were being listed there. And it was said that they have not performed the due diligence, but the Karnataka High Court came to the conclusion that they were merely intermediary, and they have played no role in terms of actual listing of the goods. But I just thought I'll finally share with you on this particular topic an interesting observation that came in the context of a job scam, against which Reliance Jio complained, and this was happening on the portal of Quicker, and and it's very interesting to know that how the judge views the argument of the defendant, where the defendant has argued that, look, I do not actually play any role in listing of these jobs on my portal. There is an automatic process, and I do not have the mechanism to determine the authenticity of the parties who are placing these jobs listing on my portal. The judge was very clear, and this was his the lady judge whose observations, prima facie observation. The ruling has yet to come in this case. Was that you are running this portal not for charity, but you make income from it, and your claim that the system auto generates these listing. And there is no mechanism to ascertain the authenticity of it cannot be accepted. If there is some policy changes that you have to make in your system, then let it be. You will have to work on that, because you're saying that I do not play any active role has an impact on the trademarks and copyrights and the intellectual property rights of the person, as well as you are contributing to the job seekers being misled, and therefore you have not performed the due diligence. These were the prima facie observations on a first date of the hearing. The argument still continues, and we will watch this space to see how the concept of the intermediaries further develop, and how much the intermediaries are held liable. In the meanwhile, what I have not covered here is that the Consumer Protection Act has also been amended by the government, and there is a specific e-commerce guidelines now that has been placed, which puts actually quite a lot of obligations on the e-commerce portals, as well as on the sellers. And any consumer who finds that those guidelines are not being complied can actually take the e-commerce portals or the seller, as the case may be, to the consumer forum and seek damages or costs for being not being provided the proper services. And these including the providing, in case the goods are imported, they have to declare that the source of the country from where they are coming. The seller must have a policy that he should take back the goods, that the consumer has the option of the return of the goods. So many of the things which are already there in the e-commerce guidelines, are being provided by the more popular portals such as Amazon and Flipkart, but there are many other portals which do not. And under these guidelines, there is an attempt by the government to create that sort of obligation on them. And I think also there is government has seen also is that many of the Chinese companies, Chinese portals, had actually exploited a lacuna in the law, which exists even today. Was that instead of setting up a website, why don't we come to enter India through the Google Play Store by creating an app, and run the e-commerce portal through that app, which can be freely downloaded by people in India. And the Alibaba and many other such stores from China are operating or were operating in India like that. And the new e-commerce guidelines actually clamp that kind of an activity. With that, I will move to the second section of my presentation, which is in the online world, we also hear about movies and software piracy, which is quite rampant. Now, interestingly, as the virtual world has become popular, and the piracy on the movies as well as on the software has also moved from being on the CD-ROM being distributed, and early days we were commissioned by the clients to carry out physical raids at the shops, to catch people who were selling the CD-ROMs, and then and floppy disks in the early days as well as the software was being sold like that, which has changed to a very large extent. At least in most of the metropolitan cities, you do not find people actually buying pirated CDs. People no longer use the CD-ROMs, and people don't have the DVD players or the CD players at home. Most people go online and download movies and download the pirated software, which obviously is wrong, but then that's what is driving this industry. Also, another interesting, and how this industry is also moved is because there are now so many platforms where, for the software, even the software companies like, Microsoft, or whether it is Autodesk, or, many others of them are actually now providing all of their software to be downloaded online, and therefore the industry trend is that the physical form of it has kind of disappeared. Now, insofar as the the law in this regard is concerned, of course, this being a case of piracy, the copyright cases are brought against before even a movie is released on, and what is called as the John Doe orders. And John Doe orders actually was a case in US from where this name came, and was called a John Doe order. In India, we now started to call it Ashok Kumar order, because we say, we generally make a party as Ashok Kumar, which is like an unknown party. We don't know who all are, pirating, apart from what I have already discovered. So generally, when you approach the court in such cases, you identify a few of the parties which are selling, which are offering these, pirated movies, and then you say that, look, I don't know identities of some of them, and I should be allowed to add them as and when I come to know of them, and those are called as John Doe orders or Ashok Kumar orders. Obviously, there are, I was quite surprised to note that many of these, Pirate Bay websites, which offer free download of movies and music and other sort of pirated materials, make a lot of money, because there are several million people visiting these portals and downloading them, and therefore they make a lot of revenue from advertising. Roughly, I mean, the loss to the entertainment industry is huge, but we still see, these movies being pirated, and therefore, before any movie is released, many of the producers or the distributors approach us along with the producers to go to the court and obtain an order beforehand, so that the movie is not copied before it is released. And and these people, most of these websites would have various parts of the movie, what we call as the torrents, and they stitch them together to make a movie. I mean, many of if in the audience there are young people who would probably know how all of this work very well. But then this kind of a piracy continues unabated, and we, while the courts have been, at the forefront of stopping them, but still there is a big issue on the movie piracy in the virtual world and the software piracy. On the software piracy, we assist one of the, a very well-known, enterprise resource planning software provider, and they face often an issue that there are mushrooming training companies, which claim that they are an authorized authorized training companies, and use pirated software. In the COVID times, we have seen them even actually provided education training online. I mean, that is becoming more and more popular, and they actually provide you even the software for practicing and for accessing by uploading it on servers where they use a dynamic IP, so that the location of the server cannot be known. So for example, any known organization or a respected organization will always have a static IP, so that their website can be identified with that IP address. But most of the times, these the pirates would use a dynamic IP, so that the location of their server cannot be determined. Again, with the coming of these, newer way of storing things like the Dropbox, the Google, Drive, etc., are also, while it has made the business easier, at the same time, these pirators are exploiting that to upload pirated, movies, pirated software, and then they send the link to people to download it with the and then deleting all of those links. Thus, the piracy continues to flourish. When it comes to, as I was mentioning, the John Doe or the Ashok orders, the Delhi and the Madras High Court are much more liberal. And they would actually, when they see this activity, they actually order to bring down the entire website of the person indulging in certain activities, whereas Bombay's High Court would only ask that only that particular URL be brought down. And so on that, in that regard, there has been a very interesting judgment, which again came from the Delhi High Court. In this case, this was in the context of the movie piracy. So what also happens is that in these days, when you go and file a case against a pirater of a movie or a pirater of a software, and you know that the identity is difficult to trace, then you also actually make all of the internet service providers as a party to it and seek a direction from the court that they should cooperate in implementing the court order of bringing down the infringing content, because it is very easy for any pirater that if you stop him from if you close one of his websites, he will create a mirror image of the same website, which is very easy to do, and start hosting it on another address. So it is quite challenging what to do. So this particular case actually brought some of these issues which are being faced by the copyright holders in terms of how the virtual world allows anyone to copy the content and host it at any location. Once you have closed one website, it surfaces at another website at another location, without and it becomes very difficult for a person to keep going back to the court to obtain order, because general principle of filing cases against in the court being that you have to name the defendant, and get the order against the specific and named defendant. Whereas the complexity in the case of the piracy of the music or in the case of the software arises from the fact that even if you name xyz.com as the website that is hosting in pirated content, the next day you close that website, the person will come up with another website and call it xyz1.com, and it is very tough for to prepare the papers again and to go and get the order. So in this particular case, the court came up with the concept of what is called as the dynamic injunction, and which is a concept which was propounded by the Singapore court, whereby the intention was that how can a plaintiff, without having to come to the court every time, if there is a mirror website being created by an infringer or by a pirater, can use the same action to close down the new mirror website as well. So there are certain definitions in this case which also were held, which are very important from the point of view of the copyright owner. I'm not going to read all of that. This presentation would be available to you, and I can share and can go through that. I think this was important that the court decided to define what would be a rogue website. This becomes important from the point of view that I shared with you that There are certain high courts which do not bring down a complete website, because when a complete website is brought down, it obviously is helps the to sort of put a clamp on that activity in a better way, because there is an economic loss to the person when his entire website is brought down. As opposed to that, if only a particular URL where that website is hosting the pirated content is brought down, he can continue to run the website without having incurred any sort of inconvenience and economic loss. So in this case, the court propounded the test of qualitative instead of quantitative, and said that if the overwhelming material on a website is pirated, then you declare it as a website, as a rogue website, and bring that down. Coming back to what was I was telling you about the dynamic injunction. So in this case, following the concept laid down by the Singapore court, the court for the first time allowed that any website, any plaintiff or any copyright owner can approach the court within the same case. In fact, he doesn't have to even approach the court. He can simply move an application and demonstrate that it is a mirror website of the website that I have already closed down. It is the same content or nearly the same content, and it is now being hosted at another place. Then, within the same case, you can actually stop a mirror website as well from running. For now, coming to my third part of the presentation, which is about the data privacy and data theft. This is something which is very important. Probably a lot of you have seen full-page advert being issued by WhatsApp recently in relation to the change in the data privacy regulations that they issued in for their WhatsApp, portal or their service, whereby they were willing to share certain information on of the WhatsApp users with the Facebook, and there was a lot of hue and cry. And in the last 2 days, they've been issuing the full-page advert to clarify that they are not reading anyone's WhatsApp messages. They are not sharing any personal messages that you write to your friends and families. They have only changed the policy for WhatsApp business accounts because they want to target those business accounts in terms of having to have more subscribers on both their platform. You obviously know that WhatsApp and Facebook are owned by the same company, so they want to exchange the data and probably cross market their service to each other. And that's what they're saying, but it has obviously created a lot of hue and cry, and a lot of people are worried about their privacy. Now, it's often said that the data is the new oil. And, one of the examples I often give during my presentation is that, the 10 years or, even longer back, when we first tasted what was called as the home delivery service, was started by a pizza company. I don't want to name the brand, but you obviously know which one I'm talking about. They promised to deliver a pizza in less than 30 minutes, and it was a home delivery, not dine-in, and people were really happy. They had a choice to ask for an international chain, and they gave their phone numbers, they gave their addresses, and etc. And it is said that that company made more money selling the data rather than selling the pizzas. So you can imagine that how important and how valuable the data has become. Obviously, the data is collected by e-commerce portals when you are buying goods online. When you go on the social media websites such as Facebook, Instagram, LinkedIn, etc., they collect the data on what you click, what you read, what you like, and so that they can accordingly profile you. I mean, in the sense that there is no particular person sitting there who's profiling you, but there are algorithms which are capturing your likes and dislikes and capturing your data to build a picture of whether, without even asking you which gender are you, what kind of your tastes are, who all are the members in your family, whether you own a pet, etc. or not. But by just looking at your browsing history, they build a profile for you so that they can target advertising accordingly. Many times you've also seen that when you go online and you click on certain product or an advert, next time whenever you are browsing, those particular adverts are again targeted back at you. So there is a lot of data that is being captured by social media. When you do a financial transaction, of course, the banks are responsible for keeping your KYC and collecting that data. Uh, at the moment, there being no personal data privacy regulation in place in our country, it is free to share by a lot of institutions who collect our data, and whether by their own related entities, or even sometimes completely different entities. Some of the rogue players even actually go out in the market and sell the data. Now, we have a data protection bill coming up, but there is still no personal data protection. That is more on sensitive data. But what about all of these entities collecting our data? There is still regulations to come into play. Now, under the current act, under the section 43A, there is an obligation placed on the handlers of the sensitive data, and there is clearly a definition of what is sensitive personal data means, and that has been provided. And they need to follow certain reasonable security practices, and there is obviously a fine in case they do not follow those practices. But still, it is considered as inadequate in terms of this particular regulation is the only regulation in the entire Information Technology Act which talks about personal data, and but it is worded in a manner and it does not, it's not deterrent enough for companies to actually exchange data either with their own sister companies, subsidiary companies, or even sell the data outside. Therefore, there is obviously a need for a data regulation or a data protection act, which is currently being debated by a joint parliamentary committee, and I understand that it is likely that in the winter session of the parliament the bill will be laid out. I have read that bill, and it is quite a stringent bill. It has been built on the lines of the European Global Data Protection Regulations, which is considered as the gold standard in terms of the data protection. And I do hope that that comes sooner than later, so that we can be more sure that all the data handlers, whether it is the as a part of the government regulations, as a part of the statutory requirements, whether we share our personal sensitive data, or even if it is our data which kind of maps the likes of what we do is protected and not being shared indiscriminately by people who are collecting such data. There is also provision under the current Information Technology Act on data theft, whether it is between whether an employer, whether an employee who leaves the company and takes away such data, whether can be held liable under the data theft provisions. It certainly is difficult to prove, but we have done certain cases on that count as well, where we have advised. I personally advise clients where when employees leave and they set up a parallel business, and when at times they are even contact the same companies that were your clients, sending them information presented in a manner, in the same manner in which the company that they were earlier working to, which alludes clearly to the fact that they have taken away the data. And in many such cases, we have asked the courts to appoint what we call as the court-appointed receivers or local commissioners, and they have searched their computers and found those data being stolen, and therefore, these sections do come in handy at times when there are such situations. There is also provisions under the Information Technology Act on if anyone harms the computer database or introduces a virus, etc. Out of sort of his vengeance or ill will for an ex-employee or employer or for other means, they can be held liable, and there is a clear punishment provided under the Information Technology Act. As this slide would show, that there is in case you disrupt any computer system or you destroy them, there is a punishment of 3 years and fine and both. There is also provisions under the Information Technology Act on if you impersonate someone, on the identity theft. If you want to represent that you are a government servant or anybody, or these days we see regular calls being received, people posing either as insurance company brokers, bank employees, etc., and we are then that is considered as impersonation, and in those cases the these sections that are mentioned here on the this particular slide comes in handy for carrying out prosecution by the agencies, by the enforcement agencies, by the police agencies against people committing those crimes. Now, while these sections are there, it is actually quite tough to prove at times these crimes, because again, remember that the anonymity of the internet is one such thing. While we did not, you can see that every million people who go on the internet in India are the people who actually have been graduated to buy a phone because now the data is so cheap that you get literally a 1 GB of data at the cost of 200 rupees. You can use 1 GB of data every month. So people find it so cheap that they and there is less of education in terms of people's mind that how what this data can do to us if we continue to surf all of those websites which seem suspicious, and just because it is free, and they continue to browse that, and that is where the entire problem of what we see today, the scams, the data being misused, is happening. I, as a copyright, as an IP lawyer, I must also say that we are in serious need of data protection act as well. The government has very ambitious plans, and it worries me sometimes. We had the challenge to the Aadhaar as well, when they wanted to use it indiscriminately for every function to be, every sort of, in many other ways in which it was actually formulated. Similarly, with all the good intention, on the 15th August, the Prime Minister announced the National Health Mission, whereby it wants to connect every lab, in every recognized lab and every hospital on one portal, so that people, so that each doctor has access to the history of a patient. But I seriously worry, in the absence of a data protection, provisions, and a comprehensive law, such sensitive data can fall into the hands of marketers, or even scamsters, who can actually exploit a lot of people into doing things which they should not be doing. We are currently seeing people being defrauded of the about the money, the bank accounts, but the medical side of things can actually become very ugly. So that's sort of this part of the presentation. I will try and see if I can play. This is so it's not. So I wanted to show you, in the last section as well, before I move to the job scams and how the virtual world is actually exploding with the job scams as well, and which is becoming a big worry for not just the companies but also for the government and the government agencies, and how to control this kind of activity. But on the data theft, if you get the opportunity, do watch a series on the Amazon, also on the Prime. Was it on Prime or was on? I think it was on the Prime. It's called the Jamtara, which is about how the data is actually sold to these scamsters, and how they operate out of states which are at the from the towns which are at the cusp of 2 or 3 different states, making the phone calls to the gullible consumers who easily part ways to their information about their accounts, and how those accounts are then emptied by them and all the money transferred back to their accounts, and then they move from one state to another. And because our law enforcement is such that each police has their own territorial limits within which to investigate the crime, as a result, to exploit that provision, they are able to get away by being caught by moving from one state to another and making phone calls from one place and then moving into another state. But here's one of the things with the virtual world is that it moves so faster that by the time the government machinery has sort of clamped one activity, the scamsters devise another novel way to cheat people. So that takes me to the final part of the presentation. How are we doing time wise? Okay, please. This is another area which is causing a lot of concerns to people. I shared with you the case brought by recently by Geo, in terms of a lot of job adverts being placed through these portals, like the Quicker, the Naukri, and many others, the Shine, etc., where where anyone can go online and place the job advert, and then what we see is that these scamsters then ask you, very officially about your CV, and then they would ask you to come for sometimes for interview, and then ask money in the name of either clearance to be done, or many times they offer you these jobs which are overseas and ask money for in the name of the visa. Creating these fictitious websites is very easy. Again, you would be surprised to know that today, if you have to register a domain name, you can register that domain name without having to do any kind of KYC. A domain, you can just approach the domain registrar, and I can today create a domain name, if it is available, even with the best of and the most popular brand names. I can create by adding a letter here and there, or by adding a numeral at the beginning or at the back, or making some sort of words which will show as if I am the genuine domain operator. I can register a website. And many of the times these scams, either for the jobs, recently we assisted a few FMCG companies where during the COVID time someone created a website where he was offering franchisee or the distributorship of their agent of their brands to anyone who would want to take it. He had a proper application process. He had registered a domain name which was very, very close, unless you can very meticulously examine and see that it is actually fake. He copied the entire color scheme, etc., of the original company's website. And for the application to process, after one or two rounds, he would ask money, and people were happily giving away the money in the name of thinking that this was an original sort of transaction that they were entering. We have seen a number of such. One of the cases that I can share with you is where someone who knew that Hard Rock, which also it not only runs the restaurants, but they also run hotels in a number of places. They have a hotel in Goa as well, but they knew that there was a new hotel being constructed in Canada, created a website called Hard Rock Canada, and started placing adverts in shine.com. Also started sending mailers. Whosoever clicked on that, he would capture that data, send them an email, and ask for money for the visa after one or two phone call interviews, etc. And when we investigated this scam, it appeared that someone who stole the KYC documents of an old lady somewhere in Guwahati opened the bank account by impersonating. I don't know whether it was in collusion with the bank officials or not. Thereafter took the debit card, and he was actually based out of Delhi. The phone calls were made from a phone call number in Bangalore, and he would cheat the people by taking the visa fees. It went on for quite some time, and then they were even issuing these kind of letter of employment, as you can see, to make people really that it's an official thing. And the sad part of the story is that they would obviously target people with the lower end of the jobs which were like of the plumbers, the electricians, and not the managerial category jobs, so that they can actually convince those people by these kind of sort of correspondence and sending them these letter of employment. Even a declaration from employee would be taken, etc. As I mentioned, we filed the complaint under Section 66D of the IT Act, and under 419 and 420 for cheating under IPC. But ultimately, it is very difficult to actually reach out to the person who is committing these crimes, because again, as the technology is a blessing, it equally can be exploited by many people. Like, for example, I gave you this example that you could open a bank account anywhere in India, and you can operate it also from anywhere in India. You can also withdraw the money from anywhere in India. So you don't, technology has made that possible, but at the same time, you pay that price that, scamsters clearly exploit that by opening the accounts in places where it is easier for them to get the KYC done, and then, use those accounts for as much long as possible, and then, collect the money in those accounts and then close them. This was again another case that we did where the person had created a website as well as domain name for the Ritz Hotel in Paris, and he was again offering jobs to the aspiring candidates. Again, it was a proper letter being issued. In this case, they would ask the person to deposit the money because there was a medical to be done. In the first case, it was visa. In this case, it was the medical to be done for getting before they could travel to Paris to join the the hotel. even signed and everything. As you can see, the letter has been signed by the HR manager. In this case, we went to the civil court, got an injunction, shut the website, and finally, the internet service provider and the domain name registrar were also made parties, but being intermediary, they were not liable, but they did shut down the website. Thereafter, we haven't heard, but I'm sure they, target some other hotel or some other services. So, this is the virtual world, which is, obviously growing every day. It's, these are just the 4 areas. There are many other, similar challenges that the companies face, which in the short time was difficult to cover. There are also, like media influencers these days who actually, and there are cases surrounding this. So there are lots of issues in the virtual world, but due to paucity of time, I've covered those 4, and I'm available and open for any, questions that you may have, either on the topics that we discussed today or generally.
Thank you, sir, for your session. Uh, if the audience is having some questions, then they can ask it to sir. If we don't have any questions, can we go ahead with the session for the closing remark? Okay, so thank you, sir, and thank you to all the participants. Sir, thank you for your brief on IP in Online Space and Information Technology Act. You introduced your session with the question why digital world is growing fast, and you explained the reasons why people are depending on internet, in which you considered the current COVID situation also. You covered 4 topics in the session. The first one was about how and why sale of counterfeit goods on e-commerce works, and also considered about the online marketplace and how Amazon and Myntra works. During the presentation, you have stressed on legal provisions pertaining to the e-commerce portals and also on Section 79 of the IT Amendment Act 2008 and its expectations. Sir also highlighted example of T-Series, Shop Clues, and Reliance Industry. The second one was from software and movie piracy, wherein the evolution of piracy was introduced, and also loss to the entertainment industry was discussed. Also, the cases of legal action and issues related to them were covered. The third point was data privacy and data theft, wherein the data collection point sources, Section 43A, were brought to notice along with the data theft and impersonation, which also made easy to understand with the video. The fourth point was about the job scams in the online world, where online job scam was explained, followed by probable legal actions, which was cleared with the help of a fake website. Overall, it was a brainstorming session. Thank you, sir, for your session.
Okay, thank you very much. So can I disconnect now?
Yes, sir.
Okay, thank you very much.
Thank you, sir.